Hello and welcome. In this lecture of evidence law, we'll be exploring witness competency to testify. Now, this is based on Federal Rules of Evidence 601 through to the Rule 606. As a basic requirement, there are three rules for a witness testimony. So that is, every time the case is brought into court, the witness is presumed to be competent. This is under Federal Rule 601. Now, everyone competency is presumed to be as such in court. Now, this is when a situation when someone, for example, might have a mental issue or they may be a minor. The law provides that that person is presumed to be competent, unless they have been deemed to be incompetent by, say, the federal rules of evidence, or if there is an exception in civil cases. Now, civil cases usually are cases adjudicated by a state court. Now, in such a situation, the state determines the competency of the witness according to the legal rules within state law. Now, this is obviously only in civil cases. Number two, witness must have personal knowledge. This is under Federal Rules of Evidence 602. A witness on personal knowledge of the matter is required. So that means that the witness must present information that is based on their observations through their own testimony. And this does not have to include an expert testimony of the occurrences or the incidents. For example, if someone has just watched another person being run over by a car, now this is a personal observation of the facts, and that qualifies under the Rule 602. Number three, before giving a testimony, a witness must give an oath or affirmation to testify truthfully. This is Federal Rule of Evidence 603. Now, this oath and affirmation must be in a form that is what's said to be impressed or designed to impress a duty on the witness conscience. Example, in many courts, witnesses before testifying, they are called to swear by either touching the Bible, raising the Bible with their hands. Now, this is a duty upon the witness to impress upon them a moral conscience that they have to testify truthfully by performing such a solemn oath. The requirements for an interpreter competency is prescribed in Rule 604, and it says that the interpreter must be qualified and must give an oath or affirmation to give a true translation. Now, this is in situations where the language at hand is not the language that the parties to the case understand. So, an interpreter is provided, and the Rule 604 regulates this situation. Now, the next step is the judge and the juror rules under 605 and 606. Now, both rules are very important because under Rule 605, a presiding judge may not testify at a trial he or she is presiding. And if the judge presides or if the judge testifies in a trial they are presiding, then the parties to that case may not object. However, a juror under Rule 606 may not testify before other jurors at the same trial. But if the juror is called to testify, unlike the judge above, the juror testimony may be objected. In fact, the court affords the opportunity to the opposing counsel in order to object to the testimony of the juror. And this is usually done in the absence of the juror. Furthermore, During an inquiry into the validity of a verdict or indictment, a juror is prohibited from testifying. Now, the juror's testimony can be in the form of affidavits, evidence of jurors' statements, and so forth. And this type of documentation will be forbidden from being shared in court. Now, the reason is because the juror is standing at a trial where they are at that position of juror. Therefore, they cannot be both juror at the very same trial and a witness. Now, there are exceptions to this rule, which is a juror may testify about extraneous prejudicial information. Now, this extraneous prejudicial information can be in the form of anything being said outside of court that then disadvantages one of the parties. Such information will have to be shared in court. Moreover, any outside influence that is presented to a jury, such information has to be shared with the court. And any mistakes when entering a verdict on a verdict form.